No, get out of that chair.
Boss. State calls case number RC 772 of 23. State versus Bafana Mahungela. Appearances today being the 20th of December, the year 2023 are as follows. The presiding officer is Ms. Prinsloo. Public prosecutor is Mr. Bagana. There is no interpreter since the applicant understands and they will be proceeding in English. And on behalf of the applicant, it is Advocate Masako. Matter was remanded until today for purposes of the state to proceed with its case. With regard, with regard to the state case, the state will read into the record an affidavit by one of the state witnesses. It reads as follows. I, Grant Mulder, state under oath in English as follows. Before I proceed, it is the state's intention to provide my learned colleagues with the copies of these statements. But 20 minutes ago, there was a problem with our machine. I don't know whether we need to adjourn. I'll send someone to go and find out what is happening. But I'm of the view that we can proceed. What the state will do before handing the state membership will actually give to the defense.
Worship, I think I've adjusted to the getting of the documents and think of the cuff at the time. It's already the kind of practice in here, and it is not starting now. It has been like that. I understand my learned colleague wants to read it. We cannot prevent him from reading, but we'll get a statement afterwards and see how we swim or sink in this ocean of darkness is creating for us. But having said what I said, Your Worship, may I ask for permission? I know my client suffers from some kind of dehydration, and he asked me to bring him some water. Can I give it to him, please? Thank you very much. Thank you, Your Worship. I'm greatly indebted. It's fine. We'll get the affidavit. And will we be granted an opportunity to can ponder on it, at least for some time? Thank you, Your Worship.
Okay. As a court business, I, Grant Mulder, state under oath in English as follows. I am an adult male, ID number 69 12 24/7 security. Number 8, Pilo Road. conduct numbers. On 29 October 2023, I received a call from our control room stating that a deceased female body had been found at the Santin Sports Club. At George Lee Park in Parkmore. We are contracted to guard this installation. And I was the duty officer. And was conducted by our control room. I proceeded to the crime scene. On my arrival, it was established that Kirsten Claes was deceased. And her naked body was found on an embankment next to a running path. And it appeared that she had been murdered. All her clothes and shoes were not found at the crime scene. It was established that her car keys and cell phone were discovered on the running path adjacent to where the body was found. She had been pulled down into a bushy area. Down an embankment. The phone was picked up by a runner Mr. West Pal. The runner's name is Mr. West Pal. It's W-E-S-T-P-H-A-L. At around 08:18. Who at the time thought someone had dropped their phone, according to his statement. Who was participating with a few other runners. In an event called the My Run. The fourth paragraph. I received a picture of the victim which was taken on the day where the victim can be seen wearing a light blue top, black pants, sunglasses, and a tan peak cap. She can also be seen carrying her cell phone in the picture. This picture has a time stamp of 08:05. And was taken by Manuela de Nobraga Hrobla. At the start point on the victim's third lap around the circuit. The fifth paragraph. We started an investigation to assist the SAPS. and obtained footage from a few premises in the area. This was done in conjunction with my IT specialist, employed by 24/7. Lebogang Trevor Bohoshi. I started with Sandhurst Preparatory School, which has a camera looking at the western pedestrian gate. Of George Lee Park. Around 50 meters from where the body was found. Around 31 October 2023. Around 31 October 2023, full stop. On this camera, I found an African male, African male, leaving the area. In the vicinity of the body, at around 0849. Real time on 29 October 2023. Wearing a blue shirt, a dark hat, and carrying something black in his left hand. Full stop. Paragraph 6. On Monday, the 13th of November, 2023, we obtained and downloaded footage from 89 Olympia Avenue. And on the real time, it is estimated at 0852. That a person jumped out of the park. Over a locked gate near the corner of Olympia Avenue. Wearing a blue shirt and carrying items which were thrown over the gate before he jumped over the gate. He heads down Holt Street. He heads down Holt Street. His age, OLT. Towards Virginia Road, Pagmo. Full stop. Paragraph 7. On around the 14th November 2023, I discovered footage that was downloaded from 78th Street, Pagmo. Where a person is seen wearing a light blue top, resembling the victim's top, a dark hat, and sunglasses. And is still carrying something that looks like clothing in his right hand. We then went to 72 8th Street, Pagmo, where I obtained clear footage. On this footage, I can observe a tattoo on his right arm, above his right elbow. The shirt has a pattern around the sleeve, which is also visible on the victim's sleeve. In this footage, I could say that the hat was navy blue in color, and has a white rim and a logo on the hat. The person's face is visible, and he is wearing sunglasses and has shoes with writing on them. Paragraph 8. We also obtained footage from the bottom cameras. May I just indicate, I think is the spelling is actually boom cameras. On Holt Road, near the entrance, on the Sunton Sport Club, on the eastern side of George Lee Park, on the 14th of November, the year 2023. And established that a person with the same pants, hat, and shoes was visible on those cameras, and has a tattoo on his right arm, but is wearing a black t-shirt. And can be identified as the same person. His tattoo extends around his right arm, above his right elbow. On these cameras, the person can be seen behind the victim going into the Sunton Sports Club at the open gate, at the gym entrance at around 08:06, and is approximately 1 minute 30 seconds behind the victim. Just before he entered the gate, he takes what appears to be a picture of the entrance gate with his cell phone, and was also looking around towards the victim's route inside the club. Paragraph 9. On Monday, the 20th of November, 2023, I received information that the suspect was standing under a tree outside number 125 8th Street, Parkmore, for around 3 minutes on the day of the murder, which seemed suspicious. As on all other footage, he was walking. This bothered me On the 25th of November 2023, I spoke to the private investigator, Glass Mulibalo, who at this stage has joined the investigation mandated by the deceased family, and asked him to go to the above-mentioned address. He checked a stormwater drain, and he found the victim's hat in the drain. Paragraph 10. We downloaded the footage from the address and determined that the same person disposed of the victim's hat and other items in the drain. He then moved back to see if the items were visible from the road. He pushed more items in the drain and dropped what looked to be clothing. He then put that clothing into the left side of the drain and proceeded to walk up 8th Street. The father of the victim is paragraph 11. The father of the victim did send me a reference picture of the hat, and it matches the one found in the drain. The Santin SAPS duty detective came out and put the hat into an evidence bag and booked it in at the station. And the IO was informed. Paragraph 12. On Sunday, the 26th of November, the year 2023, I accompanied the investigation officer to number 145 8th Street, Parkmore, which was established to be a possible address of the suspect. The SAPS investigating officer arrested the suspect and found clothing matching the footage at the suspect's residence. He was later detained at Sentin SAPS. Paragraph 13, I know and understand the content of the statement. I have no objection against the taking of the prescribed oath. I found the prescribed oath to be binding on my conscience.
Statute is marked Exhibit N.
Bishop, I'll humbly request that before handing the statement, I give my learned colleague, legal team, an opportunity to have it. But what I've done, as I was busy reading the statement into the record, the second statement that I'll be reading, I've made sure that the copies for my colleagues, that is the legal team, is made.
Let me respond. Worship, I think logic dictating itself to common sense is that we're still trying to digest the first affidavit. It defeats the purpose because once he gives us the second one, whilst we still have to read that first one, we humbly request that it's okay, let him proceed to read both of them. He'll give both of them after reading all of them to us, have a short adjournment, read both of them, because what's going to happen? And it's common sense, we'll be distracted. Once he gives us this one, we're still thinking about the other one. So fairness prevailing would guide us that the best to be done in this circumstance, let him keep them for now and divorce us from that. We'll marry with them at the right time.
I'll proceed then, Bishop. The second statement. I, Aubrey Chisani, state under oath in English as follows. I am a detective sergeant in the South African Police Service, stationed at Sentin 02 Summit, Morningside. I am the investigating officer on the Sentin case number 797/10/2023. Murder of Kirsten Glaze at George Lee Park, Parkmore, on the 29th October 2023, while jogging with others. Paragraph 3. I was apologies, Bishop, I'm just distracted.
I'm sorry.
I'm just distracted.
I'm the cause for it because I'm trying to tell my attorneys what to write and not to write. I'm sorry about it. It's me. I know. Mea culpa, mea culpa.
Jogging, eh?
While jogging with others, Bishop. Paragraph 3. I was tasked to investigate the above matter as the member who was on standby for serious and violent crime investigation. Full stop. Paragraph 4. During the crime scene visit, I was informed that the deceased was jogging with others while they were running, and she was walking, reason being that she was pregnant. While running, one witness picked the cell phone from the ground around 08:15 a.m. and handed it to the timekeeper, who is also the witness on this matter, and count their laps during running. Next paragraph. After everyone finished their laps, it was discovered that one lady did not complete her laps, and they started their own investigation for logout of this lady. They then went back to where the phone was found and conduct their own search. And the body of the lady, that is the deceased in bracket, was found on the bushes, wrapped and naked. Next paragraph. All role players were called to attend the scene, and body was removed thereafter from the scene to Hillbrow Mortuary. Next paragraph. During the attendance of the postmortem, I was informed by the pathology doctor that the cause of death was blunt force head trauma. Strangulation, smothering, or pressure to the neck cannot be excluded. Next paragraph. After the postmortem was attended, I went back to the crime scene to investigate and gather evidence to assist trace the suspect. On arrival at the scene, I was informed about the camera, which is at Sandhurst Preparatory College School, which is next to the crime scene. Footage of the day of the crime committed was viewed and saw an individual coming wearing a blue t-shirt, carrying something on his hands on the side or next to the crime scene. And more footage was collected on the surroundings after seeing the first footage to track down this individual. Next paragraph. Witness statement was then taken from the people involved during the jogging, where it was established that the timekeeper took a photo of the deceased when she have to do her last lap at 08:05 a.m. And deceased was wearing a blue t-shirt, glasses, black trouser with white stripe on the side, a brown cap, watch on the left arm, a black shoes with white sole, and also carrying cell phone on her left arm with earphones. Next paragraph. Camera footage was viewed at the entrance of the park, where I saw the deceased coming into the park at around 08:04 a.m. And the pictures of her was taken by the above witness at the starting line, which is plus minus 100 meters away from the entrance. Next paragraph. I also saw an African male coming past the camera footage from the entrance at around 08:05 a.m. wearing a blue tracksuit, a black t-shirt with white sticker on the left, hat with white sticker, cell phone on his right arm. Black and white shoes with writings at the bottom, and having a tattoo on his right up elbow, which was the time when the deceased was taken pictures by the timekeeper. And he waited at the entrance, looking at his phone, and then entered inside. After I viewed the footages and analyzed the time frames of the incident, it came to my attention that the witness picked the phone at around 08:15 a.m. and the deceased entered the park at 08:04. And the timekeeper took pictures at 08:05. Meaning the murder occurred in the period of plus minus 8 minutes and the deceased was found naked. I'll repeat it, Your Worship. And the deceased entered the park at 08:04. And the timekeeper took her pictures at 08:05, meaning the murder occurred in the period of plus minus 8 minutes, and the deceased was found naked. I then looked at the footage of the person entering at the park, wearing a black t-shirt, and the one wearing a deceased t-shirt, and saw that it was the same person. I followed this person, that is the next paragraph. I followed this person on different camera footage. And I saw this African male throwing a cap inside the drain, and went back to check if someone can be able to see it from the distance. And he also threw another cloth which looks like a panty inside the drain. Investigation continued, and the drain was opened and recovered the cap which belongs to the deceased, and the other items were not found. At this point in time, informers were tasked, and suspect was identified and arrested by the name of Bafana Mahungela at his place of residence at number 145 8th Street, Parkmore. And he was shown a picture of the person wearing a blue t-shirt. And he confirmed to be him. I then concluded that the suspect was following the deceased on the day of the murder by looking at the footage, witness statement of the person who picked the cell phone on the ground, and the time frame of both the accused and the deceased of entering the park and planned to kill her. Together with the information received that the deceased was part of the jogging every time it happened, I concluded the suspect may be monitoring the deceased and planned to murder her. And I measured the suspect distance from his place of residence to the park, which gave me plus minus 1.4 kilometers by using the route he used after the commission of crime. The suspect was remanded in custody after his appearance, and matter was postponed for bail application. I therefore opposed bail of the accused person as the accused planned to murder the deceased. Kirsten Clays, and he wore her t-shirt after murdering her and raping her. My apologies, Worship. It's actually not raping, it's raped. I'll repeat this. And he wore her t-shirt after murdering her, wrapped the body to cover her from being seen, and destroyed the evidence by throwing it inside the drain. If the suspect can be released on bail, members of the public community will be in danger, and also the safety of himself, the suspect. The suspect must remain in custody. I know and understand the content of the statement. I have no objection at taking the prescribed oath. I consider the prescribed oath to be binding in my conscience. This is the second statement.
I'm going to speak O, I'm going to mark it Exhibit P.
As a court, we have been able as a state, as an application was made, to make copies of the two statements for my learned colleagues.
Is that the evidence being filed today?
It will be the state's case, Your Worship. It is the state case, actually.
How much time do you need?
No, I have revisited my thoughts. I thought the affidavit would be coming with something out of this world which would change the complexion. If court allows me to be flexible, I can start my argument now, adjourn to deal with material inconsistencies and other things contained in the two affidavits as I continue with my arguments. Can I start? Right. May we hand in our copy of the heads of arguments? That will be one for the prosecution, then one for the Honorable Magistrate.
Your Worship.
There's no accused, unfortunately. I would have given him on the other side, but he will listen. What are you guys going to do with this? Do you want a copy? Just one copy, and the manner in which you guys are sitting, it's fine. As the introduction to our heads of arguments, I think it is logical that I must start by showing that the affidavits presented amount to absolutely nothing, and they don't resolve this matter, and they do not even at least try to assist this court. I haven't seen the affidavits, but I want to check something which I can tell the court before I proceed. If one looks at the Commissioner of Oaths stem, one will realize that it mentions the following. I don't know which statement did they start with. The statement of, who is this? Grant Mulder. I know and understand the contents of the statement. I have no objection against taking the prescribed oath. I find the prescribed oath to be binding on my conscience. And it has to further still say, aver that the facts are within my personal knowledge, and where they indicate otherwise, that would be facts which I receive from a third party. Because we need to remember vividly, bail application, unlike a trial, does allow hearsay to be heard. But my learned colleague must produce authority which says double hearsay and hearsay of other people who never gave any affidavits before a court can be seen to be reliable, and is the veracity of it counts for something. That's the first thing. Let's be understood. Hearsay evidence is allowed, but once you refer to third parties, that it's no more hearsay. It becomes double hearsay or third hearsay, fourth hearsay. Now they have to answer, and they'll get their opportunity. As to why they didn't secure other confirmatory affidavits from those primary sources. Second issue which I wish to deal with is that, may I go back to the issue which I dealt with when I raised preliminary objections. What did my learned colleague say? In his own words, I now read. The state prosecutor said, I quote him, "It is a state submission. Further, there were items, property that belonged to the deceased that were taken, allegedly running shoes, sunglasses, 8 t-shirts, and the pants of the deceased. The state at the present moment is still busy with further investigations. Fortunately, at this stage, the PM report is available, and in terms of it, the cause of death is as follows. It is an unknown blunt force, a head trauma, strangulation, smothering, as well as pressure of the neck." My learned colleague proceeded to say the following. The deceased body was found naked. Then he further says this, and I wish the court to note this. If there is a red pen, I humbly request the Honorable Court to use its red pen on this point. The state alleged that video footage obtained showed Mahungela following Kirsten Clade at some stage, leaving the place where her body was found. The same footage allegedly showed Mr. Mahungela jumping over a locked gate, and before that he was captured, apparently throwing away some of her clothes. He was allegedly also seen wearing her t-shirt. Fundamental question to be asked is, was he acting honestly, fairly to the defense and the accused person about saying, and it's a vow. We must remember and not lose sight of the fact that for us to be acting as advocates, we took an oath. And we know what the oath stands for. Among other things, I shall not lie. I shall ensure at all relevant material times the truth and nothing else but the truth shall be. And I shall remind myself from time to time that I'm a public servant who has to serve with and really show elements of trust, credibility, good reputation, and be an agent of the NPA, not the BWK. See, the National Prosecuting Act shall be my guiding act, code of conduct, and there is also a book on ethical guidelines. I know it's written by, among others, the late Mr. Jan Jenne, who was an acting national DPP before Mr. Mokotedi Mpshe could be. Now, this video footage is of crucial importance. Why? All these things which are averred. No. Before coming to that, to proceed, I write a letter to my learned colleague asking what? To see the video. And that's what I also requested from Mr. Mafiri, the prosecutor who was dealing with the matter in court 2 on the 5th of December. Mr. Mafiri said to me, and I can personally say from the bar, as an officer of this honorable court, that the gentleman who's sitting next to, on the left side of the prosecutor, I'm not sure if he's the one who deposed of an affidavit. When we were in Mr. Mafiri's office, he said,
with greatest respect, may I raise a concern? The concern from the side of the state, or the question, what is the obligation of my learned colleague? My understanding is the following. At this stage, all that we need to do is to address the court with regard to a judgment. Now, I'm confused because the very same argument that he is making, it was made long ago. And I'm still of the view that we need at this stage to address this honorable court with regard to the evidence that is before this honorable court. I really don't know, maybe if we can understand, because I'm confused now. The state have closed this case. Before that, the defense closed its case. The state was given an opportunity. State have closed its case. Now we need to assist the honorable court with regard to the merits or the facts that are before this honorable court. If I can be assisted in that regard.
Mr. Masako?
Your Worship will recall the issue of the video footage was set in this court. I'm giving a background. The issue about the video footage, not the change of heart by the prosecution, that they no more had the video footage, they were going to use photos, was set in this court. The issue now shows its ugly face in the affidavits. Now, should I leave that unattended?
You may proceed.
Thank you very much. And the confusion of my learned colleague, I think it's pressure. He has to relax, pull his thoughts together.
Mr. Masako, please.
Thank you.
Please proceed with the question.
Thank you, Worship. Now, the essence of what I'm saying is that the issue about the video footage was raised with Mr. Mafiri. The gentleman who's moving out of court now showed me on his phone some photos. As to where do they come from, I don't know. And I said it earlier on.
I'm going to object again. As I've addressed this court last time, I'm not Mafiri. Whatever was discussed by the defense and Mafiri, I was not there. And again, I would like to mention this before this honorable courtship so that it can be noted. The very same day that my learned colleague addressed this court about this Mafiri confronted him, and I was called by two of them disputing what my learned colleague is saying about this Mafiri. I don't think it's relevant. It's hearsay. I was not there. Otherwise, Mr. Mafiri, he needs to call him to come and testify with regard to that. I was not part and parcel of that.
Mr. Massaf, what is the relevance of your case with regards to Mr. Massaf?
I can't believe that when I'm addressing in argument, I can be interrupted like this. It's totally out of order, if I may put it, Your Worship. The purpose of me bringing this is to show that the previous prosecutor who dealt with the matter promised that video footage. My learned colleague, when I came for the first time on the 13th and with my attorney, changed and said the video footage was not going to be utilized, but photos would be instead of the video footage. Now the relevance of that is that in the affidavits now, we are referred to a video footage which was not shown in court. Do we find that to be fair? I respectfully submit that it is not. The video footage information is only known by the prosecution, the state, and BDK. We didn't see the video footage. The court hasn't seen the video footage. Therefore, any finding made by this honored court hinging on the video footage shall be found to be assailable. That's a point I wish to make. But also it goes to the ethics. Let's try at all costs, be it a bail application or a trial. The right to a fair trial, which is enshrined in the Constitution in 35 and 34, that the accused person, when bringing an application, has to be granted a fair hearing. This fair hearing has been prejudiced by all these tricks which have been played in a court of law. Authority, and if this matter, really, if this public which is referred to hears all this, it creates cessation. That's another point which I wish to make. Now, let's agree and let it be common cause that no video footage was shown, and in this statement, any information referring to the video footage with respect, Your Worship, has to be expunged. This is another point which I wish to make. That was just nothing else but an introduction. A proper introduction comes now. Why are we here? We are here for nothing else. Liberty of a young man who's 21 years of age, coming to pray before this honorable court for what? Equal justice and sympathy. And why is it doing that? Section 9 of the Constitution, which is the supreme law of this country, spells it very clearly that we are all equal before the law and we deserve equal protection before the law. And I'm not talking about formal equality, I'm referring to substantive equality. High court cases, in fact, constitutional court cases have dealt a great deal about Section 9. And I need not to belabor this point any further. What is this case not all about? In our humble submission, this case is not all about the charges preferred, which are murder, premeditated, pre-planned murder. If one looks at what the state relies on to back the issue or to create a basis for the pre-planned, premeditated murder is, and I wish to remind this honorable court, during cross-examination, I never heard a word from my learned colleague that at any stage you had an intention to kill this person and you wanted to kill her on this day, and when was this intention formed, and for what good reason to kill this person. And the issue about knowing this person for the very first time when she was under a rag was not disputed. No cross-examination said. You knew her 3 months before, a year before. You and her had a quarrel about 1, 2, 3. Nothing should be noted. What the state relies on that? Is it the statement of the IO or the IO? I mean, really, if it's not far-fetched, it's remote, and if it's not remote, it's fanciful. And I'm saying that with the greatest respect. There's a lot I can say, but I think I'll cut myself short for purpose of ensuring that all the points which I intend to make are being covered. Let's now come to robbery with aggravating circumstances. Evidence which is before this honorable court is that the accused, in his viva voce, not affidavit, and really if we were to compare an affidavit with viva voce, what has to supersede? Common sense tells us that viva voce has to. Why does it have to supersede the affidavit? It's because he was subjected to cross-examination. The court had an opportunity to observe his demeanor. The court had an opportunity to check. And all these things about credibility, they are for the trial court. But we, as frank and honest as we are, we said we fear absolutely nothing. Go into the box, tell the truth. The crux of his truth is as follows. Admitting to the blue t-shirt which belongs to the deceased, the clothes which he threw in the drain, which were later discovered. We even showed that t-shirt, powder, is a sky blue t-shirt, is of the value of approximately 250. That was not disputed. And even in the affidavits, nothing. Why am I following this trail of thought? It's precisely because I want to show this honorable court. And I also wish to remind the honorable court about M1 and M2, which was only, and the court has the originals, we need to have copies of those, M1 and M2. M1 refers to 1003, which is the timeline which does not marry, tally, or which is not consonant with what the affidavits are saying. So they don't speak to each other. Why? But they belong to the same case number, the same investigating officer, the same prosecutor in the same court in Alexandria, who have the expertise of reading the docket and understand it fully well. But what's even disturbing about M2, which shows that there were no genital injuries, is that it's marked in red. And what's even more shocking about it is lack of honesty about it. It's marked in red. We had to push to get, because the issue of pregnancy was only introduced during cross-examination. And had we not asked on what basis is the state relying on what's the basis of the state saying she was pregnant, we wouldn't have known. And even when we requested, they were still holding the document up until we requested it, and by sheer luck we got it. And what would have happened if we never got there? The court wouldn't have known the truth, to the prejudice of the accused. Now, what this case is not about is that it is not about murder premeditated, pre-planned. It is not about robbery with aggravating circumstances. Why do I say that? Simple. Viva voce evidence says, I found this person covered in a red, dead, facing the wall. curiosity which kills the cat became his problem. Went there, touched the body, and I'm not going to repeat what he said. He said it loud and clear. Now, found out the crucial question now becomes: if you find a body in its dead state, by undressing it, hiding the clothing, wearing the deceased top, can that satisfy the elements of robbery? I don't know, not the robbery which I know from a book called Sneyman. I think now is that the 6th edition. The elements are very clear. You apply force to a person, hurt them with a view of taking their property and depriving them. Now, if indeed it's robbery, what kind of robbery is this which is selective? In that it leaves the car keys, it leaves the phone. Which phone could have assisted the state to check who communicated with the deceased? What's in the WhatsApp of the deceased phone? Could have taken fingerprints also, because the version given now is that the accused person never touched that, and that's why he left. So that could have assisted gravely, but what did they do? They funneled. They said, we've got video footages, and we'll apply our imagination, speculation to arrive at a conclusion. The law doesn't work that way. And emotions also. The law doesn't work that way. Even in China, where they don't respect human rights, they don't behave this way. Now, let's come to the rape issue. May I not delve deeper on this issue? My simple submission is M2 resolves the issue. From their own report, what is this case all about? This case is all about a young man undressing a white lady. Oh, no. In fact, I'm jumping the gun. A young man seeing this rag, curiosity, as I alluded, checked with a view of assisting, because this person is in an unnatural position, heartbeat, checking whether they're breathing. Is that not help? Which means if this person had any hope of life, he could have resuscitated him. Because obviously, when you check heartbeat and what have you, it changes the whole complexion of this case. Now, this is about a blue, simply put, blue top belonging to Christian Clays, which was taken by my client, who doesn't deny it. Even when he was arrested, he confessed to that, even when he didn't have his lawyer. And even in court, testified consistently that I took it. Now, I wish to draw court's attention to the following. If the state, which is a very powerful machinery, could just react based on what they see on the video footage and they jump to arrest somebody, arbitrarily so, what would happen to a 21-year-old who does not even know the law? Shock, anguish can make you do stupid things. And indeed, in human life, the person who coined the phrase "to err is human" anticipated situations like this. We are not, and we need not be armchair critics. You know, to be wise after the fact can be sometimes a fact which doesn't make us arrive at a sane conclusion. Because and that is what was said, somebody is not normal, but they're in court. If they were not normal, we could have not proceeded with the bail application. I couldn't have called him into the box. We would have applied section 77, 78, 79 for him to be taken to a mental hospital to be checked. But we respectfully submit that he is normal, he is sane, and his coherent, logical, convincing, unassailable version speaks for itself. Now, I now deal with my heads as they stand. Where are they? Thank you. Thank you, Bishop. Maybe I'll get copies of the affidavits if time allows.
I've given you the copies of the affidavits.
Yeah, they're here.
Yeah.
They're here.
Yes, what do you mean then?
No, we're not fighting.
I'm not fighting, I'm just asking.
We're not fighting, please.
Come down.
We're not fighting, please.
You don't even saying, Chief.
Chief,
No, we are not going to tolerate that behavior.
You see, that is why I said you must come here to be my witness also.
We are not going to tolerate that behavior.
And if you think you have emotions, you also have emotions. We are not going to be scared by you. Right?
Leave him, man. You want to talk alone? No, I want to talk alone. Just leave him. You know, Mrs. is going to talk until tomorrow. He's going to talk until tomorrow.
Audrey, rest, my friend. Rest.
But already speaking the thing.